Ukiah Love. Hopefully, I'm not messing up your name there. Winston. So I appreciate you answering questions. I received a judgment against me in Michigan. Judge ruled against me, even though I did not receive the paperwork from LVNV. So I guess two questions. Was it a default judgment where the judge said you just didn't answer, or was it that the judge said at trial you lose? Uh, Default judgment really just and I'll tell you in Alabama, it may be different in Michigan, but in Alabama, the question with a default judgment is, were you served? I mean, if you were properly served, then it's kind of like the stopwatch being clicked, okay? And you've got either 14 days or 30 days to respond. And if you miss that, then they can get a default judgment. Now, if it was at trial and the judge just didn't make them produce papers, then that's really going to depend on Michigan law, okay? In other words, can you ask the judge to reconsider it? And the more formal name of that is typically called a motion to alter, amend, or vacate. And most states have very similar numbered rules, what are called the rules of civil procedure. And that would be under Rule 59. But again, it could be a little bit different in Michigan. And if you cannot do that, or even if you can, you may still want to appeal it to a higher court. You just have to see what the rules are. And again, I would check out some lawyers in Michigan that are consumer lawyers, and there'll be some there that deal with these lawsuits, and they can help you with that. And I'll put the link again because I'm not exactly sure how these comments are sort of scrolling, but it should be toward the bottom. You'll see the link to that. It's the National Association of Consumer Advocates. So sorry you're dealing with that. I hope that will help you there. Let's see, Yukila, can I appeal? Again, that's going to depend on Michigan law. I don't know what your time limits are. I will tell you this, in most states, the time limits are set in stone. And I mean, if you miss the time limits, it's too late. But if you're within the time limits, then you can appeal. The question will be the type of appeal that you're doing. Let me say this. Typically, there's two types of appeals. One appeal is from a lower court, kind of like a small claims court, and you appeal to the higher court, and everything just starts over. Okay, the higher judge doesn't care what happened in small claims court. Okay, and sometimes that's called a de novo appeal. But then there's another type of appeal, and this is the more common appeal, where we're going up to an appellate court, and they're just looking at the record and saying, do we agree with the trial court? Do we disagree? Those tend to be much harder to win those appeals because it's sort of like going to the U.S. Supreme Court. They're not going to take testimony. They're just going to look at what happened with the lower court and then say, did that judge make an error? So it certainly is possible you can appeal. But again, I would get with a lawyer in Michigan about that.